burning the midnight oil, right? On the midnight before they're out of office. And Marshall is sitting there and he's gathering the commissions and he is supposed to be delivering them. It's his mistake that he is then a judge, the Chief Justice then ruling on. So that itself is a historical note about judges and the appearance of fairness. There's a whole longer conversation we can have about today where we have judges on both sides of the aisle who raise questions about their political interests. In fact, right now there's a case I'm working on where Judge Kavanaugh, he ruled that a federal agency, the agency that Elizabeth Warren designed as in Congress, Kavanaugh has already, as a lower court judge, ruled that that agency is unconstitutional. And now his court is going to hear it. And I've had 3 text messages in the last 3 days asking whether Kavanaugh should recuse himself from that. That is, I actually think he shouldn't recuse himself. But Marshall is having to decide, he's basically saying, so one answer to your question, and this is called legal realism, right? There's the law, and then legal realism asks, well, what are the real motivations? What are maybe the political or personal motivations? Some people say, what did a judge have for breakfast? There's a study, and a judge had a good breakfast and he's more lenient towards a defendant. A judge had a bad breakfast and a set of Israeli law professors created a study where they looked at similar crimes and they looked at how Israeli judges ruled and sentenced defendants. And if it was right after breakfast or right after lunch, the sentences were lower, and the further away they got away from a meal, the sentences got longer. Okay, so that tells you. So then one other little on this rabbit hole. It turned out that then lawyers then tried to game where their client got scheduled during the day, and then it confounded all the studies. To bring this back to your question. Chief Justice Marshall rules that you don't have to deliver a commission, it's just the commission itself that's property. Who gets to benefit from that result? By saying it really didn't matter whether it was delivered or not. Well, except Marbury doesn't benefit in the end, right? When we get to step 3. Who personally, in an emotional way, of let's say alleviating himself of guilt?
Adam?
Yeah. What's that? Well, Adam's a little, right? But Adam's didn't mess up, right? Yeah, Marshall. Marshall's basically, part 1 is basically saying, nothing my mistake didn't matter, don't blame me, but he gets to decide, as a sort of a hidden defendant there, my failure to do my job, don't worry about that, it didn't matter, it was just Adams filling out the commission. So one step is just recognizing that this result isn't just driven by law, it might just be also driven by his own personal sense of vindicating himself and saying it wasn't his fault. But is there also a legal hook to that? I mean, where there's a legal will, there's often a legal way. I think the point is, what he basically is saying is that filling out the piece of paper fulfills the legal step, and the point is that he said that actually delivering the piece of paper was a custom. And I think what he's saying is that the office is not the paper, right? Owning the paper is not the same thing as an office. And so let me just say 2 more words about that. I think what he's emphasizing here is that in a democracy, it's the office that matters. If you were in a more aristocratic or monarchic government, that piece of paper is the title. So when your family buys a house, they get a deed, a piece of paper that they have to hold because they're going to hold that piece of paper as claim to their house from one generation to the other, right? To own permanently that piece of property. I think part of what Marshall's saying is that piece of paper is only custom here. The office itself is of a limited duration, but it's that office that's legally significant. So it's understanding on both a legal sense and also a more personal sense.
So if the piece of paper is only custom and the Records Act doesn't require the delivery of the paper, why bother with a mandamus at all? Why is this case about a mandamus? Why not just say, you don't need the piece of paper, just go sit on the bench?
So I think what they're saying is that this is so here's the flip. So why is it called a writ of mandamus? Let me put it up here. Let me put this up here. It's called a writ. Now, that is both a piece of paper, right? So the reason why we have writs is because back in the 12th and 13th and 14th century, the way that the king created new rights was by creating a series of new writs. Mandamus is one of, let's say, a dozen major writs that create the Anglo common law system. So these are all based on pieces of paper. But that is the process, right? That's the process by which you got vindication for your rights. That piece of paper unlocked a door, right? And that is the issue here with which court has jurisdiction. So you're highlighting an interesting irony here, that in the first point, let me just clarify what Dr. Caden is saying. He's basically saying in step one, the piece of paper didn't matter, right? Piece of paper didn't matter here. It's the office itself. But when you get to step three, where you brought a different piece of paper, the writ is let me just be clear here. The way that the writ system worked is they had very formal rules about what your piece of paper had to say in order to unlock a key to the court. And they're saying, well, where you bring that piece of paper, a writ, meaning that comes from the idea of writing. That writing has to come to the right court. It's a great question. I think my best answer is that it turns out that when it comes to property, when it comes to public property, public offices, the piece of paper is not the key.
So this case is not about the commission then?
No, the case is about the commission. I mean, it is about the filling out. The president has to fill out the commission. The president creates the office. It's not the holding, it's the filling out. So I think this is another answer. In step one, the key is that the president has to fill out the paper. He can't just declare, I'm giving this office to Marbury, I'm giving this office to Marshall. He has to fill out the piece of paper, but then it can go to a government office and sit there. It's not, the point is that, and this connects to the person who said it's a right and a wrong, who said the question about is there a right and is there a wrong, right? The issue of the wrong is really who fills it out, right? Once the president fills out the piece of paper, it creates the property right. So the piece of paper matters there. But who holds the piece of paper doesn't matter. So because of that, and that unlocks the key to the office. The president fills out a piece of paper, that piece of paper becomes a key to the public office. In the same way, where you bring your piece of paper, the writ. So actually, Dr. Caden, I think this is a more precise answer to your question. The piece of paper matters, and it depends upon where the key is to what opens the right or opens the power. The president filling out the appointment commission creates the office, right? In the same way, if you're a plaintiff, in law school we always use the Greek letter pi for plaintiff. The plaintiff has a writ, but he's got to bring it to the right court. And if you bring it to the wrong court, you lose, right? So I think that's and I'm using the word key as the metaphor. So I hand over here. Go ahead.
So wouldn't that mean that the office was already given to Marbury?
Yes, exactly. He's saying that the office he already had the office. Yeah.
But so since he went to the wrong court is why he didn't get the office.
Exactly. The question was which court, when you have a writ, which court do you go to?
Okay.
Okay, and that's step 3 here, right? So let's just review. So step 1, does Marbury have a right to the office? Yes. Marbury, the plaintiff, wins step 1. And if there's a right, Chief Justice Marshall says, and the unanimous court says, there has to be a remedy. If you have a property right, there has to be a court that's going to give you that property right back. Then step 3 is, okay, then you have to find the right court to go to. Now we're coming back to, where do we start? Ezra, this is step 3. Because then this is the question of if there has to be a remedy somewhere, the question is where. So Ezra, let's come back to that. Yeah.
I was just wondering, wait, so you're saying that, are you talking about the commission is the key, right?
The commission.
But if you don't physically have the commission, then it doesn't matter if it was written or not, right? Because you have no proof.
Well, that's an argument for the government. That's an argument for Jefferson and for Madison. But Marshall rejects it. He says that you don't need the commission. right? So Miranda's question, I think, is interesting because it's basically, it's not obvious. Part of what Marshall's saying, it's convenient. It's very convenient that Marshall says his own mistake didn't matter. But I think what I'm saying is that there's a legal reason, there's a legal principle there, which is what creates the office? It's the president filling out the commission and delivering, and it could just go right into a government office. Let's say, the new Department of Justice that they've just created holds. In fact, there is. I fibbed there. There was no Department of Justice in 1789 or 18. The Department of Justice was created in 1870. Little footnote. But it sits in the. Let's say the Attorney General has a big cabinet where he says, "Where are my JPs?"